My name is Michael Garth Moore. I'm a trial lawyer. I work in the area of civil rights. I've represented many families who've become entangled with children's services and criminal cases arising from issues related to their children. I've won settlements and judgments for many of those families. But a victory in a civil suit many years after the incidents that caused such injury to the family cannot remedy all the damage done. Most parents never even consider the possibility that they will have a knock on their door by police or children's services investigators questioning them about their conduct towards their children. Even fewer consider that they might be approached by law enforcement regarding alleged conduct of their child. I'm here to give you some guidance, 8 points actually, on how you as parents might respond when that knock comes on your door or when that call comes. Understand, though, that each interaction with law enforcement is unique. I'm not giving you specific legal advice as to what any particular situation might call for. My goal here is to give you some general pointers, general guidelines that can help you in a practical way if you are ever approached. What I want to say first is that I use the term law enforcement to cover both police, sheriffs, other law enforcement officials, as well as children's services investigators and workers. If you ask children's services investigators whether or not they are law enforcement, or whether or not they're there because of any alleged crime that you might have committed or your child committed, they will deny that. They will tell you they're only there, their only goal is for the best interests of the children's health or safety. But just remember that whatever you say to a child services worker, you might as well be saying to the police, because that information, more than likely not, is going to be passed on to the police. So this will help you understand why it is so important to understand that these two arms of law enforcement, police, sheriffs, and children's services investigators work hand in hand. Further, and of great importance, is that unless what you say is recorded, you have no assurance that that investigator, or that police officer, or that sheriff's deputy will actually report what you said. There are police and children's services workers who, unfortunately, lie. In a situation where you're approached by a police officer or an investigator, you're not going to know whether that particular officer or investigator has any motive to be anything other than completely truthful about what you allegedly say, or what your family says, or what your child says. Moreover, unfortunately, even attentive officers and investigators sometimes make mistakes and write down in reports later something that is inaccurate and not helpful to you. If for no other reason, you should make no statements to any law enforcement agent whatsoever. Now, as to your constitutional rights, every parent who has custody of a child has a constitutional right under the United States Constitution to control that child's life in the sense of making decisions about health, making decisions about medical care, making decisions about education, and all those other many decisions that you as a parent have to make relative to your child. The child also has a right to your, as the parent, your care, comfort, and affection. So your child has a constitutional right, you have a constitutional right. These are not independent in that they are together. So if a child is seized by the police or by children's services workers, both constitutional rights have been, how do we want to say it, divided. Both constitutional rights have been affected. And if that seizure is unconstitutional, then that's an unconstitutional seizure, meaning that you have a legal remedy, and so does your child. The police and children's services must have probable cause that you are neglecting or abusing your child in order to remove that child from your care and custody. Sometimes if the investigator has a court order, if they've sought and obtained a court order, there's nothing you can do about that. They have the absolute right to seize your child and remove the child under certain circumstances. In many instances, though, these children's services workers do not obtain a court order before they take your child. And that's when they're vulnerable. Because, ladies and gentlemen, because a child misses a few meals, it's not neglect. Because you spank your child is not necessarily abuse. And oftentimes you will not know what the allegations made against you are at the time the child is seized. Remember though, there is no legal basis at any point for the police or children's services investigators to seize your children simply because you will not answer their questions. You should know this. Virtually all visits by law enforcement personnel to your home about your children, and I'm including now law enforcement being children's services workers, are brought about by a 911 call to the police or one of the 800 number hotline calls that each children's services agency sets up in its area. Seldom, if ever, do the police or children's services workers investigate the reliability of the caller. Ordinarily, if a caller gives his or her name, they take that as that the caller is reliable, at least in the sense that the caller is not falsely making up things. Unfortunately, in many, many, many cases, that's not true. But remember, often, in fact, in most cases, there is no investigation of the history of the caller before the children's services worker comes out for his or her investigation, or the police come out for their welfare check. When the agents do show up at your door, they are not going to disclose to you the details of the accusations that were made against you, nor will they disclose to you the name of the individual or individuals who are making these reports. That will be left up to you to try to guess, and you should not be in a position of trying to guess when you're speaking with these folks. In those instances in which your child stands accused of some wrongdoing, it's more likely that it'll be the police that comes to your door. It may be children's services. It may be both. Children's services will be there to purportedly investigate whether you have neglected or abused your child and thus led that child into this antisocial behavior. The point of the matter is, these agencies want to get into your home and they want to question you in a situation where you are hardly prepared to do it. Remember this, though, because law enforcement will visit your home in most instances only after they receive a call and without any further investigation. there is no probable cause or necessarily even reasonable suspicion to remove a child or to threaten you with removal. So here are the points that will serve you best. Whenever you answer the door and one of these law enforcement agents is standing there, number one, be courteous at all times. There's absolutely no reason for you to get hostile or angry or give anyone a reason, and particularly Children's Services a reason, to claim that you were obstructive or that you were abusive to them. Number two, never allow these agents to enter your home. Ever. An agent may inform you, a police officer, even a Children's Services worker, that they have a warrant or they have a court order that allows them to come in to your home. If they say that, then all you do is say, "May I see the warrant? May I see the court order?" If there is such a warrant, if there is such a court order, there won't be a problem with them giving it to you. And in fact, you have a right to read a warrant or read a court order and understand it before you ever allow these folks in your home. In virtually all of the cases, when they make these approaches to you, they have no warrant and they have no court order because they have no basis to get one. If you refuse admittance, often a police officer will say, "Well, I can go get a warrant. Why don't we just do this without that?" Invite the officer to get a warrant and to come back. Because again, without probable cause to enter your home, they can't get probable cause to obtain a search warrant. You're being intimidated. Number three, immediately ask for identification if there is no badge or name tag for this person. Remember the name of the people that come to your door. Remember them, and remember everything that happens, because at the end we're going to be talking about you writing down everything that does happen. Number four, ask when you are informed that there's been a report what the substance of the accusations are, what the actual accusations are. Sometimes they may actually tell you some things. That is all good information for you to have. 5, if the agents begin asking questions of you at the door, decline to answer. This is just a corollary of the adage that you do not have to answer. Advise the agents that you will answer any questions once you have a lawyer present. Once you have a lawyer present. Tell them that you're going to need some time to find a lawyer. Ask them to give you their cards or to write down their contact information and give it to you so you can call them and let them know when you are ready. I think you'll find in many instances that the police or the Children's Services investigators will kind of brush that off. But you need to make that statement. Once you've made that statement, you need to stick to it. Now, if you see the agents at the door before you open it, it's a good idea to get out your cell phone or another recording device and answer the door with that recording device in your hand, recording the conversation on audio. You don't have to try to video this incident or event, but it's a good idea to have it on audio. Now, in virtually every state but I think one, it's perfectly reasonable and acceptable and legal for a citizen to record police officers or Children's Services investigators when they encounter them. However, you don't want to hide it. You just want to have it in your hand, available, they can see it. Even in those states where the law says that you can legally record, if an police officer tells you to turn it off, forget about a Children's Services investigator, but only if a police officer tells you to turn it off, turn it off. Do not give the recording device or the cell phone to the officer, and if the officer tells you you have to, decline to do it and step back from the door. Put the object, put your cell phone or the recording device down on a table or down on the floor behind the door, or hand it to your wife or someone who is there inside. You do not have to deliver that up to the police. If they do seize it from you, again, it's a constitutional violation of your rights, and it is actionable. Number 7, if the agents that show up at your door are police officers or sheriff's deputies, you want to see if they have body-worn cameras on them. And the body-worn cameras are ordinarily a small box here with what looks like a camera, the eye of a camera on it. Remember whether they have body-worn cameras on them. 8. This is so important. Law enforcement agents know that they are intimidating by their very presence. And many will use that intimidation, and unfortunately many are taught how to use intimidation in order to get you to talk, in order to get you to allow them to enter your home. For example, if you decline to speak, you might hear, and you often do hear, "Well, I'm sure you don't have anything to hide, do you? Don't you just want to talk to us here rather than down at the station?" Well, the fact of the matter is they can't take you down to the station any more than they can seize your child. They cannot require you to come to the station, and again, unless they have an arrest warrant for you. Such a statement is simply bluster and intimidation. Again, once you decline to speak, do not give in. Do not answer. Even if they have an arrest warrant, even if they have a court order, even if they have a search warrant for your home, none of which chances are they will have. Nothing can compel you or your child to answer any question. There is no legal right for them to ask you any questions under those circumstances. Do not speak. And finally is this part. The intimidation factor is significant because you will be sorely tempted if you think somehow you can wrap this up and make this all go away just by letting them in the house and speaking to them. You're wrong. Again, when they come to your door, 99% of the time they have a completely uncorroborated, probably unreliable statement and nothing else. They rely on you and your statements and your admissions and letting them into the house to see your children to try to supplant that and to give them probable cause so they can remove the child. Do not give in. Now, as soon as the encounter is over, sit down, write out in detail everything that you can remember. Question and answer, question and answer. Everything you said, which police officer or which investigator said what. Write down the names and the contact information. Write down if the police officers had body-worn cameras on them. If it was police or sheriff at your door, you then want to reach out to a criminal defense lawyer. If it was children's services, you want to find a lawyer who's very familiar with litigating in juvenile court with children's services. You can find very good lawyers on websites such as avo.com, Justitia, those types of sites. Generally, those lawyers have profiles. Generally, those lawyers have been vetted. You can rely on the fact that they are who they say they are. You must seek that legal advice, and it doesn't really, even a small consultation fee is very, very important here. Because that lawyer can get the lay of the land and let you know whether you can expect more, and if so, under what circumstances and how you prepare for it, or can tell you this thing looks like it's over. And of course, once you have that lawyer and you've consulted the lawyer, if you are ever questioned, if another police officer, another investigator appears at your door, calls you on the phone, or stops you in your car, you simply say, my lawyer's name is X. Please talk to him. I have nothing else to say. I can't guarantee that these strategies will work in the sense of the police folding up their tent and walking away, the same thing with children's services. I can't say that because every situation is unique. But the fact of the matter is, if you don't set forth your constitutional rights for yourself, no one else in that situation is going to do it. And if the police understand that you do understand you have constitutional rights, and the children's services investigators do, more likely than not, they are not going to move forward with something they would otherwise do. I hope this has helped. Thanks very much.